So in property, we're still talking about land use regulations, but now we're moving on to zoning, and specifically, we're only going to be covering the basics of zoning and the constitutionality of zoning. I did look at the last episode and how long it ended up being, so I'm going to try and make this a pretty quick episode. There's still a lot to cover when it comes to zoning, so I'm going to just try and breeze through these as quick as possible, but at the same time, I do need to give enough information because the cases that we have now are constitutionally based issues, and as a result, these cases are actually going to be more relevant, and so I may spend a bit more time talking about the details of the cases than I normally would for the previous cases that we've talked about so far in property. So, what is zoning, and how does it work? Where did we start? Where are we at now? Well, traditionally, landowners could do whatever they wanted with their property, but because of rapid development in the United States, private use without any public intervention caused a lot of serious concerns, specifically habitability concerns that we've talked about before, lots of slums, and so the United States, the government recognized that they had to do stuff to actually fix this, and the solution was zoning. And so what is zoning? Well, ultimately zoning is you have property that is owned by private owners, and you tell owners what they are allowed to do with that property. Some property is zoned to be residential. Others is zoned to be industrial. Others are kind of to be in between where you have office spaces. And so ultimately, these different zones are set out to where if you look at a map of the city, you can see here's where you can build homes, here's where we're going to reserve space for businesses, and the whole idea of it is to have kind of this garden city, this beautiful layout of a city from section to section, and to plant a little here, plant a little there, and to make things look nice, have a beautiful city and a well-functioning city. And this kind of grew from the idea of England, where a garden city was first established in England. And so zoning ordinances are established to, quote-unquote, protect this garden. And this first started in New York in 1916, and then it eventually started spreading rapidly throughout the 1920s. But there's a whole lot of constitutional questions that comes to zoning. Are these ordinances allowed? Are you allowed to restrict how owners can use their property? And enter our first constitutional case, Village of Euclid versus Amber Realty Co. So Euclid was a huge development of how zoning laws were allowed. This was a case where Ambler wanted to. They had the property and it was zoned in a certain way, or at least they wanted it to be zoned in a certain way to allow a lot of industrialization and then minor residential development. And the city of Euclid wanted, it was kind of like a suburban type of city, I believe, out of Cleveland, kind of a suburb of Cleveland, Ohio. And they wanted to maintain that, and so they wanted this property to be zoned mostly residential. And so, consequently, this zoning would have a huge detriment of value to Ambler. And so Ambler didn't want this, and so they challenged the constitutionality of this zoning ordinances. And so this is what we end up calling Euclidean zoning. And this is the standard that is still the case in most places, and it's a rigid standard. Ultimately, the test that we use is if there is a rational basis based off of the police powers of the state. Again, that's going to be testing the health and safety and the public welfare of the state. Then the ordinance is going to be found constitutional. So this was a major victory for zoning ordinances. This was a case where the court did find that there was a rational basis for the zoning format that was followed, and ultimately Ambler lost the case while the city of Euclid or the village of Euclid won the case. So, what does a typical zoning ordinance look like? It's a legislative act coming from the city, and it contains two parts. It's going to have the text of the ordinance. This is going to be detailing what you can say like a legend on a map, what kinds of zones are available, what they look like, what those zones are going to cover. And then you've got a map of the city that's going to implement the ordinances. So you pull up the map, and you're going to see this yellow section is residential, this orange section is going to be industrial, this green is going to be commercial. And so that's what a typical zoning ordinance looks like. What if a property is not conforming to the zoning, and that was the case before the zoning ordinances was there? If a property is not conforming with the zoning ordinance, and it was like that before the zoning ordinance was passed, then the property is going to be protected from the ordinance. You don't need to adjust the property. You don't need to tear down the building to comply with the zoning. And this protection is going to pass from one owner to the next owner continually as long as those structures continue to stand the way that they are currently standing. So you don't need to worry about conforming to zoning if that was conforming before the zoning had occurred. So let's talk about amending or changing zoning. Are we going to have a rigid structure or a flexible zoning structure? Well, to preserve the integrity of zoning, those who created zoning limited how parties can actually change the zoning laws. So there's ultimately only three ways that you can change zoning. That's going to be through zoning amendments, and variances, and then any conditional uses or a special exception. Those last two kind of go together. So let's talk about zoning amendments. Well, it's pretty straightforward. It's just an amendment to the zoning ordinance. Generally, these amendments are going to be discouraged. Many of these amendments would, if you have a lot of amendments, it's going to decrease the legitimacy of having a comprehensive zoning plan because people are just going to end up doing whatever they want anyways. And also you want to be careful with amendments because they may influence bribery. If a land is valued more from one version, then that property owner could bribe the city legislature to say, hey, if you zone it this way, I'll give you a large sum of this money that I'm ending up saving. So it leads to corruption. And so what's the standard that's going to be used for amendments? There needs to be a standard. Ultimately, the standard that is adopted is the rational basis standard. So zoning amendments are typically passed pretty easily as long as there is a rational basis for that zoning amendment. What's a variance? Well, zoning laws allow city lawmakers to provide variances, and these are going to be options for applications if any literal enforcement would produce significant hardship on the property owner. So what this means is here's zoning option 1, here's zoning option 2. If zoning option 1 is going to be too hard on you, then you can do for zoning option 2. And this produces the case Detweiler versus Zoning Hearing Board in Lower Salford Township. There's a quote from this case that I want to read out as far as outlining how to establish a variance, or rather how to obtain a variance. To establish a right of variance, the landowner must show that the effect of the zoning ordinance is to burden property, 1, with an increased unnecessary hardship, 2, that is unique to the property, 3, that the hardship was not self-inflicted, 4, that the granting of the variance will not have an adverse impact on the on the public health, safety, and welfare, and 5, that the variance sought is the minimum variance that will afford relief. So, just working through these elements and how they kind of are defined. With the unnecessary hardship, even if there is another available purpose, whether that's agriculture or industrial, a limitation on another use is an unnecessary hardship. Unique to the property is pretty straightforward. For the third element, with whether or not the hardship was self-inflicted, a hardship is not self-inflicted just by knowing of the existence of the ordinance. Self-infliction occurs if the homeowner purchases with a specific intent to obtain a variance. And for the granting of it, for the fourth element, with the police powers, you can say, of the ordinance, granting the variance does not adversely affect the public welfare or interest if it negatively affects the value of the public use of neighboring lots. Ultimately, self-interest is not a good reason to contradict a variance. You need to have a public welfare interest and to actually contradict the granting of a variance. Let's talk about conditional uses or a special exception. Zoning ordinances a lot of the time are going to write in exceptions. If individuals apply and meet the standards for those exceptions, they may be authorized to use a way that is different from the original intention of the zoning. So in other words, if the property owner meets the conditions of different zoning requirements, then they are authorized by these special uses and to use the land differently than what was previously done. One last thing I want to mention about zoning is that there's kind of this trend to move away from this Euclidean zoning to kind of this more, you can say modern approach to being more flexible. Everything that we've talked about has been pretty rigid so far with the zoning amendments, the variances, and the conditional uses. But the new approach likes to use additional tools to alter pre-existing zoning ordinances. Some of this is conditional zoning, which we just talked about. There's a floating zone, which is a zone that is detailed but is not applied to the land until someone actually applies for it. There's a cluster zone, which is a residential zone that limits the number of homes in that zone but allows a developer to choose where those homes are located. And then you have a planned unit development, which is just pretty much a cluster zone that authorizes the developer to use that zone for all uses. So cluster zone is just residential, planned unit development are all different types of zones. Ultimately, it's allowing more flexibility in commercial entities and private developers to draft their own zoning ordinances. So that's zoning. Let's go ahead and sum up everything that we talked about. We talked about the basics of zoning, the definition, the constitutionality, how zoning ordinances are drafted, what happens if a property owner is non-conforming to the zoning before. And then we talked about the rigid or flexible different standards of zoning and how you can change. And the rigid approach is zoning amendments, variances, and conditional uses, whereas the new approach does utilize conditional zoning, but it also affords floating zones, cluster zones, and planned unit developments. So that is zoning. Have a good one. Bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice. And with that, the fourth thing is if it is used as legal advice, we are not liable. That is, law scholars is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.